Hello, this is Matt on the Moon Lambo channel. Attorney John Deaton says things are about to get really heated between Ripple and the SEC. Now, I'm going to assume at this point, most of you, and I know not all, but most of you have probably heard the big headline, which is as follows. Here's a headline from you today. Ripple scores major win against SEC as judge authorizes William Hinman's deposition. Now, in my very last video, I covered that, so that's not what I'm going to be doing here. But Attorney John Deaton, who of course is the attorney seeking to intervene in the SEC versus Ripple case on behalf of over 17,000 XRP holders, he shared his opinions on what questions, at least to start, should be posed to the SEC and Hinman also. Which was an interesting thread, so I wanted to share that with you. Also, I asked the XRP community on Twitter if you could ask William Hinman any question under oath, what would that question be? And not surprisingly, I did get what I was hoping, which was a bunch of hilarious answers. Now, there were some really thoughtful ones too, but I pulled up several, and I'm going to share with you a couple funny ones and a couple serious ones. Now, I refuse to take life seriously, so I answered the question too in my own tweet, and I refused to take my own question seriously. Also, take a look at this. Look at this article from Cointelegraph. This is absolutely astonishing. You guys have to hear this. This is titled, Rep. Tom Emmer introduces bill to provide certainty for digital assets. So let me just tell you right now. They're talking about a bill, which is being proposed. And if passed, it would provide certainty to all cryptocurrency, that the asset itself cannot be a security, like just by the nature of its existing cannot be a security. If this were passed, and if it is what I believe it to be, and I admit I haven't read the bill yet, but I just, the surface level stuff from the article, if this were passed, and if this is being accurately described, then XRP, if this were already passed, and Ripple, even if the SEC still had gone after Ripple, claiming that they sold XRP in a way that was inappropriate, XRP would not have been removed from exchanges. Most certainly not, because it would be clear that the asset itself is not a security, but the SEC hasn't provided this clarity. Now there's a bill attempting to push this forward here. But I do want to be clear at the outset, I don't have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything that I say or write. And so let's go ahead and jump right on in. And again, for the sake of this video, I'm just going to assume that you're caught up to speed on what has happened with William Hinman being deposed. He is going to have to answer to Ripple's attorneys under oath. And that is fantastic. That is a huge win potential, and I outlined why. It has strong implications for Ripple's fair notice defense, which is actually a crucial aspect of this case, and it could be game over for the SEC if that goes well for Ripple. And so here's what Attorney John Deaton wrote. The fight over the Hinman deposition has now just begun. It will be a heated meet and confer meeting, I can promise you that. If I was a lawyer for Ripple, I would find out immediately if the SEC intends to object to several basic, non-privileged questions about the Hinman Ethereum isn't a security speech. And so the speech he's referencing there is the one from summer 2018 when William Hinman came out after drafting up a speech with fellow SEC employees and stated that Ethereum in its current state, and this is not all he said, but certainly in its current state, is not a security. And which is always interesting to me because the rationale used to determine that, if applied to XRP, would indicate that XRP actually is also not a security. So here you go. And because look, here's the other thing. Let me say this before I read further. The SEC, we know what they're going to. They don't want to answer any damn questions. Like William Hinman, he will answer as little as possible, obviously, right? So what they're going to do to try and get around this is claim that there's SEC privilege, like we can't be talking about this publicly. It's super secret SEC information. That's effectively the argument that's going to be made here. But there are certain questions you could ask that clearly have nothing to do with privilege. And so what John Deaton is proposing, you'll see as I read through this, is are they even fighting on these questions, these issues, which clearly have nothing to do with privilege? That's what he's asking right here. And so number one, how many drafts did the speech undergo? 2, who helped draft or compose the speech? 3, who reviewed the speech before you gave it? Excuse me. 4, Did you submit the speech to any of the commissioners or chairman? And 5, anyone outside of the SEC assist you? 6, what research, articles, publications, or technical resources did you review before giving the speech? 7, what input did the founder of the Ethereum Foundation provide you before reaching your opinion? And that's relevant too, because we now know that about a week before the speech was given, William Hinman did meet with people over at the Ethereum Foundation, and I don't believe that specific names have been made public to this point, but we do know that definitely happened. Number 8. What other digital assets did you review or compare to Ethereum before speech? I swear, if XRP was compared, I swear to God. Number 9, did you send any emails or messages with any lawyers or staff at Simpson Thacher before giving that speech? So let me pause there. Simpson Thacher, that's the law firm that William Hinman worked at before he began working at the SEC. And Simpson Thacher has strong interests in Ethereum and the Ethereum Foundation, financial ties, right? And so Simpson Thacher continued to pay William Hinman while he was working at the SEC. Then when William Hinman stopped working at the SEC, he went back to Simpson Thacher and began working there again after providing legal clarity to Ethereum, which clearly benefits his previous employer, who became his current employer now. Well, how about that? How convenient is that? Number 10, list each person you spoke to about the speech before giving it, etc. And so we wrote, notice I haven't asked what was said yet, so there is no privilege argument. Many more. Exactly. So I think this is an interesting strategy just to see what the SEC is going to do here, because I wouldn't be surprised, being that they're basically just a bunch of asshats. I would not be surprised. In fact, I would expect them to push back on everything. These are not good people. And then John wrote, but if the SEC is going to object to these basic questions, I would go to the judge and ask the judge to appoint a special master, i.e. the judge herself or a retired judge, to preside over the deposition and rule on objections live on the spot. Just a few of my initial thoughts. Yeah, well thought out indeed. And it will be very interesting to see how this all unfolds. To what degree is the SEC going to push back, and to what degree will they find success doing that? I mean, it just sounds to me like the judge ain't having it. So, I mean, yes, there could be things that are legitimately privileged, in which case, fine. It's possible to step too far in terms of what your line of questioning, but the SEC is going to pretend like everything is over the line. It's going to be a bunch of nonsense. And there are legitimate questions here that need to be asked. And so I think now it makes sense to turn to the XRP community to find out what should be asked. And so here's what I tweeted out. I wrote, if you had the opportunity to question Hinman under oath, what would you ask him? And so I'll answer my own question first. I wrote the following. I would ask Hinman, if you could be an animal, what animal would that be and why? So hard-hitting questions here. No, the truth is, I refuse to take any aspect of life seriously if I don't have to. I refuse. And so then I wrote, for the record, I think that he would decline to answer this hard-hitting question, citing SEC privilege. Oh, I can't tell you what animal I would be. That's privileged SEC information. That's exactly what would happen right there. And then here's Martin Volk. I love this answer. This might be my favorite. This is from Martin Volk, XRP community member, answering my question about what he would ask William Hinman under oath. And he wrote, I would have to ask him this. Is cereal soup? Why or why not? The hard-hitting questions from Martin Volk, everybody. Is cereal soup? We got to know. I love this stuff. Here's something from Brian Randall, who this is what he would ask. If you were a hot dog, would you eat yourself? I'm gonna guess yes. I don't know for sure what he'd say, but his real answer would be, that's privileged SEC information. Hot dog. I can't tell you that. Privileged SEC. That's exactly what would happen. Sound all stodgy. Now here's a serious one from Corey Lyons. He'd ask, what is your opinion of the security status of Ethereum? What is your opinion of the security status of XRP? What makes them different in your view? Also, why do you think you can take money from an Ethereum-invested firm, but think nobody would bat an eye? He wrote it wrong, and then he corrected it in the different. Why do you think nobody would bat an eye at this situation? Excellent questions, absolutely. I've been wondering this for some time. Comparing XRP to Ethereum, what the hell does that look like? I would love to see that answered, because I know just the framework that he outlined in that 2018 speech. If you go by that framework, it's very clear that there is a lot of similarities between Ethereum and XRP in terms of what they're looking at to determine whether or not each of those is a security, which is why this whole thing is just ridiculous. One of many reasons. And then Got That Crypto Fever would ask Hinman the following, if he could have him under oath. He wrote, when giving your own personal speech on Ether, who is we? And so this is a key point, and you may recall that William Hinman is now claiming that his speech was just his personal opinion. That's it. It's not the official stance of the SEC. Of course, that would make, because if it were, then that would make it harder for the SEC to win. And in fact, Ripple's fair notice defense would just make it that much more likely that it would stand. So they don't want that. They certainly don't want that. So who is we? Well, clearly back then, in 2018, he said we because he was referencing the SEC. This is their official policy. And if that doesn't count as their official policy, why would you trick people into thinking that? Because clearly that's what everyone on the damn planet thought that it was official. I remember covering this back then. It was very clear. Everybody was taking it as gospel. And it was presented as gospel. And then he went on TV and he used the word we. He used the word where. Okay, so he didn't say me and I. Like, that is not what he said. And so it's very clear that this was the SEC, but that's no longer convenient. And so now he's saying it was me. It was just me. It's I. It's just my opinion, right? Which is a bunch of garbage. And so asking him who is we is an excellent question, most certainly. And then into this. You guys are gonna love this. It's actually kind of infuriating in a way because we all know that there's not sufficient regulatory clarity. We know that the SEC is harmed investors with the actions that they've taken against Ripple. We know that it's been very harmful, the fact that for innovation and many other things, that the fact that the SEC has not had clear guidelines for how to legally participate in crypto and blockchain in the United States. We know this. They can pretend like that's not the case, but it's a bunch of garbage, and we're not buying it. We are not buying what they're selling here. And this is understood by others in high-ranking positions, thankfully. And so this bill here that is discussed, as you'll see, if something like this were in place, and in place on a federal level, then we wouldn't have seen the devastating fallout that we saw with the price of XRP. People would not have lost their entire life savings, and some did because of the SEC. And I know the price of XRP bounced back, but they didn't know that. They didn't know if it was going to go to zero. I was there. I understand how scary the times were. Absolutely. That was the most legit concern about XRP I've ever encountered in my entire life. And I've been around since November of 2017. There's nothing even close to that outside of that. So I totally get it, and I feel for those people. The SEC doesn't care because they're awful monsters. But yeah, I have nothing but sympathy. So check out this article. And the timing of this is perfect. Think about it. This comes out on the day where we have this awesome news about William Hinman, how he's going to be deposed. Anyway, so U.S. congressional representatives introduced a bipartisan bill on July 15th with the goal of providing a clear definition of assets such as digital tokens and other emerging technologies under current securities law. Known as the Security Clarity Act, the bill was introduced by Rep. Tom Emmer, Rep. Darren Soto, and Rep. Ro Khanna. This legislation seeks to change the definition of a term that has been used for more than 75 years. The status of any asset sold as an investment contract would become an investment contract asset. Now that's a key term, the following here. According to the release, this bill would provide a solution for those who have complied with current securities registration requirements or qualified for an exemption. After meeting these requirements, entrepreneurs would be able to distribute their assets without the fear of any additional regulatory burdens. And now here's a quote from Emmer. There has been an unreasonable approach by regulators as to how federal securities laws should be applied to transactions involving the sale of blockchain-based tokens, and this lack of clarity is hurting American innovation. between regulation by enforcement and the varying legal decisions regarding the classification of these assets, regulatory uncertainty has hindered the growth of blockchain technology, leaving many to take the technology overseas. That's golf clap for Mr. Emmer, killing it right there. I especially love the part, the whole thing was great, but the part about regulation by enforcement, that's disgusting. That's what the SEC is doing, which is why I keep saying, like, these are not good people. They don't have your interest in mind. They do not care. They just want to sue everybody into oblivion, and then you're supposed to watch and see who got sued to figure out how you proceed moving forward. It's absolutely disgusting. It's repugnant, and this is how they're acting. And then the article states, the Securities Clarity Act is meant to be a technology-neutral bill, according to the representative. It would apply equally to all assets. Now listen to this. Tangible or digital, and states an investment contract asset, like a digital token, is separate and distinct from the offering it may have been a part of. That's key right there. The token itself, separate and distinct from the offering. So just like we know with Howie, oranges are not by nature security, just like this XRP, clearly not a security in and of itself. And this bill, if it is what they're presenting it to be, and again, I haven't read it, but if it is exactly what they're presenting it to be, then this would make it so that there is no question any longer. XRP is not a security, nor is any cryptocurrency or any token just by the nature of it existing. It's not a thing. None of them are. Zero of them are. It's all about how they were sold. So that part of the law would stand, and fine. And that's why I say, like, if, I'm not saying Ripple did anything wrong, but if Ripple did anything wrong and they have to pay a fine because they sold XRP as an investment contract, if that's what's agreed to, okay, fine. I'm not saying I agree to that, but damn it, just, you wouldn't have John Deaton coming after you if something like this were in place, because we're just saying, hey, this is our XRP. Why are you lumping us in here? And the SEC absolutely is. Bunch of asshats. So anyway, I will go ahead and wrap up there, but there's going to be a lot to talk in the coming days and weeks. I am not a financial advisor. You should not buy or sell anything because of anything that I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.